right, kids. Welcome back to Hawk Droppings with me, Hawk, on Monday, July 1st, 2024. Now, I guess it's been, I'm recording this at 9:45 at night, so it's been 14 or 15 hours since we got the Supreme Court's decision in Donald Trump's immunity case. And I'm going to discuss this in a couple of different ways. The first thing this morning, around 7:30 or so, I was watching some of the initial coverage, and I was looking at this decision, looking backwards, looking towards the past, and thinking about the January 6th case itself and the implications that this decision would have on that case and that trial, and whether or not that trial would go forward. And I felt somewhat okay about the decision at that point in time. Obviously, as the day has rolled on, I've had time to read the opinion, the dissents, the concurrences. And when I read all of that from the perspective of looking forward for future presidents or a second Donald Trump administration, my opinion of this ruling changed quite dramatically and took a very, very negative turn. So the court essentially created some categories of immunity here. And when you think about them in just kind of a surface level way, they don't sound unreasonable. A president should have immunity from criminal prosecution after he leaves office, or she, relative to core constitutional duties and acts taken in furtherance of those core constitutional duties while that president is in office. It doesn't seem unreasonable. That perspective to me does not seem unreasonable. You can't have presidents, think about what the Republicans want to do right now to Joe Biden. They want to prosecute him criminally because of how he's handled the southern border. That's an official act as the president, deciding on border policy and how to enforce border policy and how to shape border policy. You can't have a president be prosecuted for those kinds of things after they leave office. The second category is acts committed by a president in office that are of a purely personal nature or for a purely personal benefit. Those acts don't qualify for any kind of immunity. Again, number one, number two, those both seem reasonable. But as with every Supreme Court case, especially with this Supreme Court, the devil is in the details, as we will discuss shortly. Then this third category of official acts, that are sort of on the outer perimeter of the president's official acts kind of thing, where it's a little murky. There's a presumption of immunity, but that presumption can be rebutted by the government with evidence. So what does that mean? That whenever I'm trying to explain the concept of presumption to folks, I did family law in California for about 10 years, divorce law and stuff like that. When two people are married in the state of California, if they are married for less than 10 years, then they separate and get divorced. The presumption is that the supporting spouse, whichever spouse is the breadwinner or earning more money, is going to pay spousal support to the spouse who is the supportee for half the length of the marriage. So if you're married for 8 years, you're going to pay support for 4 years. And by presumption in this context is a burden shifting exercise. It shifts the burden of proof from one party to the other. And in California, if two people are married for 10 years, the presumption is that you're going to pay spousal support for an indefinite period of time, potentially for the rest of your life. And so normally when a spouse is seeking spousal support, the burden of proof is on them to prove that they need it. Once you hit that 10-year mark, the presumption shifts that burden to the spouse who would be paying support to prove why they shouldn't have to pay support for the rest of their life. So in this context, by saying that, these official acts, which could be on kind of the outskirts of presidential activity, that there's a presumption of immunity for those, it shifts the burden from the person who's the president to prove that those were official acts. It shifts it to the prosecutor to prove that they weren't. So it's a burden shifting exercise. Another example of that I like to give is Wisconsin, the state of Wisconsin, their self-defense law. In most states, if you shoot and kill someone and claim self-defense, the burden is on you, the shooter, to prove that you were actually acting in self-defense. And one of the things that we learned in the Kyle Rittenhouse case is that the Wisconsin self-defense statute has that burden shifting provision in it, which in other states, the person who's the shooter has to prove that they were acting in self-defense. In the state of Wisconsin, that burden shifts to the prosecutor to prove that that person was not acting in self-defense. And it's like, how do you prove what is not in someone's state of mind? Incredibly difficult. It's very hard to prove in the state of Wisconsin that somebody was not acting in self-defense, which we all learned the hard way. But so it's like absolute immunity, presumption of immunity, and then purely personal acts or acts for purely personal benefit, no immunity. Which, again, it's like when you're looking at just the surface of things, that doesn't seem entirely unreasonable or radical. But again, the devil is in the details. And just to give some context here, today's Monday. This decision was released today. Over the weekend, Donald Trump on Truth Social was circulating posts about prosecuting his political opponents, invoking televised military tribunals, and calling for the jailing of President Biden, Vice President Harris, Senators Mitch McConnell, Chuck Schumer, former President Mike Pence, Adam Schiff, Liz Cheney, Adam Kinzinger, Nancy Pelosi, Jamie Raskin, Pete Aguilar, Zoe Lofgren, Benny Thompson. Those last few were members of the January 6th committee. He shared one post that said Elizabeth Cheney is guilty of treason. Retruth if you want televised military tribunals. So the former president spent the weekend telling the entire general public that he is going to prosecute who he perceives to be his political enemies and who he sees as his persecutors from the J6 committee. He is being very, very open and upfront with this. And then the court comes out today with this decision. Now, let's parse this down into pieces a little further. This morning when I was watching some news coverage, I had read a couple of quick overviews when I was looking at it in very narrow terms of looking at the past, because Donald Trump is not in office. Right now, there's nothing currently that he could do to get more immunity for. We know the universe of the things that he did while he was in office, specifically the things that he's accused of doing within Jack Smith's indictment for January 6th. There's nothing to add to that right now. And so I was looking at this opinion, this decision from that context, and from the context of, okay, how's this going to impact the trial? And initially I was like, that doesn't look good for the trial. However, when I saw that there were portions of this case that were going to be remanded, basically returned to the district court, Tanya Chutkan, for further analysis, determination, hearings, those kinds of things, I was encouraged by that as well, for the following reason. The Supreme Court has said to the trial court, you have to make certain determinations of official versus personal, and this category kind of in the middle where a presumption applies. You have to basically go through the facts and the allegations within the indictment. It's about, hang on. I got it. Oh, I had it here. Oh, maybe it's in my bag. So the indictment in that case, in the J6 case, is 45 pages long, and it's very fact intensive. And so I was like, okay, well, I was thinking about the options that Judge Chutkan has as far as how she could go about making those determinations. And one of the ways that the court suggested, the Supreme Court, is to have a hearing and have each side present some evidence. And one of the options that will now be available to her is to schedule a hearing and tell Jack Smith and his team and Donald Trump and their team, okay, come to this hearing and be ready to present some evidence so that we can go through these specific allegations in the indictment and determine so that the judge can make a determination as to what's official and entitled to absolute immunity, what could be official and has a presumption of immunity, and what's purely for personal benefit and has no immunity. And here is I want to try to offer you guys some good news here. So here is what I see as kind of the silver lining of all of this. Judges at the federal and state level, trial judges, it's generally understood that they have complete control over their courtrooms. They have control over scheduling trials, scheduling hearings, setting the structure and the ground rules for hearings, things along those lines. And remember that scheduling orders are not appealable. An order from a judge that deals with scheduling cannot be appealed. Presumably, the results of this hearing could be appealable, but we're going to have to wait and see on that a little bit. But what this does, it gives Judge Chutkan the opportunity to basically tell each side, show up for this hearing. It's going to last several days, if not a couple of weeks, and be prepared, especially to Jack Smith. Be prepared to call all of your witnesses to testify. And that would happen publicly. Jack Smith has filed a request with the court that this hearing not be televised, which is bumming me out severely. Because again, it's like, I mean, the American people deserve to see this shit. They deserved to see the trial in Manhattan. And that opportunity was taken away from them. They certainly deserve to see a presidential candidate who's already been convicted of 34 felonies, is going to be sentenced in 10 days, go on trial a second time for trying to overturn the results of the last election when he's running in this current election. This whole thing is fucking absurd. Pardon my French. However, Judge Tanya Chutkan does have significant opportunity and control over that hearing, its duration, its structure, and the amount of evidence each side will be required to put on during this hearing. And that could be extensive. You know, we could see Mark Meadows testifying for 2 full days. about Donald Trump's conduct between Election Day and January 6th, or even January 20th, for that matter. All right, coming back to this a little bit. There were two things about this opinion looking forward and looking back that just freaked me the hell out. One, the majority invented an evidentiary standard, and I'm going to come back to that in a second. Two, well, let me find it here. The court highlighted essentially 5 schemes that Trump and his cohorts engaged in following Election Day. First, he and his co-conspirators used knowingly false claims of election fraud to get state legislators and elected officials to change electoral votes from Biden to Trump. Second, Trump and his co-conspirators organized fraudulent slates of electors in 7 targeted states and caused these fraudulent electors to transmit their false certificates to the vice president. Third, Trump and his co-conspirators attempted to use the Justice Department to conduct sham election crime investigations and to send a letter to the targeted states that falsely claimed that the Justice Department had identified significant concerns that may have impacted the election outcome. The court focused on that one, the third one, Trump's interactions with the Department of Justice. And the majority found, so in determining what fits into that first category, official acts that are deserving of absolute immunity, that has to do with the core functions of the office of the presidency and specific powers or whatever that's delegated to the office of the presidency by the Constitution. One of those is the executive branch, running the executive branch. And this court, and appointing executive branch personnel, firing executive branch personnel, this court found that Donald Trump's interactions with the Justice Department that I just described to conduct sham election crime investigations and to send a letter to targeted states that falsely claimed that the Justice Department had identified significant concerns that may have impacted the election outcome. This court found those described activities to be entitled to absolute immunity because it's Donald Trump in the office of the presidency communicating with the Justice Department and making Justice Department personnel decisions, which are exclusively reserved to the president. And, well, there were 3 things that I found most disturbing. And they said, so that third of 5 schemes, Donald Trump has absolute immunity. Looking forward, especially considering what I just read about the people he wants to use the Department of Justice to put in prison, this Supreme Court has just told him that if he gets a second term, he will have absolute immunity in using the Department of Justice to conduct personally directed prosecutions against his enemies. And they went further and said no court, nobody from the legislative branch, and no prosecutor can examine the president's motives when engaging in such behavior. You can't look at the motive, even if it is known to be a sham election crime investigation or a sham investigation into a political opponent with no evidence. You can't look at motive at all. The entire basis of criminal law in the United States of America is based on intent, motive. What was your intent? Did you intentionally kill someone? Did you accidentally kill someone? Murder, manslaughter. if you can't look at the intent or the motive of someone who has broken the law, it becomes incredibly difficult to convict them of breaking that law. And the third thing that the court did for the category where the presumption applies, but it may be official, it may not be official, it's up to the prosecutors to rebut that presumption. In order to prove that situation, you're not allowed to rely on any evidence that is derived from official acts that qualify for absolute immunity. Conversations in the Oval Office, emails, other communications, statements, meetings. If it's an official act that qualifies for absolute immunity, it cannot be used as evidence in any other category. And those two things, you can't examine motive and you can't use evidence from one category to prove another. The United States Supreme Court completely fabricated those out of nothing. They pulled them right out of their ass and just made it up on both of those things. And that's another thing that this court does. First, Chief Justice John Roberts is a shitty writer. He's a terrible writer. Reading his opinions is always a chore. He is just a bad writer. You know, it's like I think back to Scalia. Justice Scalia was a fantastic writer, just as a writer. It's like even if you completely disagreed with everything the guy was saying, you're still sitting there going, this is really good writing. I like this. This is really holding my attention. This is very well crafted language. It's good writing. Ruth Bader Ginsburg was the same way. Fucking fantastic writer. John Roberts, crap writer. Terrible writer. So it's like you're trying to slog through this thing, but this conservative majority tries to couch the radical components of these decisions in this kind of mask of judicial temperament and restraint. There's a section in here where the majority goes through one of the arguments of Donald Trump's attorneys, and they said Trump's attorneys were saying, well, you can't prosecute a president criminally unless that president, while in office, had been impeached by the House and convicted and removed by the Senate. And they go through this, very studious analysis of that, and very reasonably say, there's almost zero support in the Constitution or our founding documents for that concept, and therefore we do not choose to accept or adhere to that argument. It's very scholarly, it's very tempered, it's very even measured, that kind of thing, and so they put those sections in there to make it sound like they're being very reasonable and high-minded. And then they're like, oh, yeah, you can't look at his motive. And you can't use evidence over here to prove something over here. And both of those two things are incredibly radical, and we just made them up. Oh, and you also can't ever prosecute a president for misusing the Department of Justice. Absolute immunity for that. And if you try to, again, you can't look at his motive, and you can't use any of these different categories of evidence to try to prove that case. That is an incredibly radical proposition heading forward, especially given that this opinion came out one day after the candidate who this opinion is for just said he was going to put 15 of his political opponents in prison and use the Department of Justice to do it. This court just told him you'll have absolute immunity for that. You will have absolute immunity for that. And so again, it's like the biggest concerns and the most concerning things for me about this opinion are when I look forward, because there's a tremendous amount of ambiguity and a tremendous lack of guidance in this opinion as to how to apply it. They barely established anything that resembles a rule, but they didn't give any guidance as to how to apply that rule. And so it's like, this is going to go back to the trial court for Judge Chutkan, and she will be very, very prepared for this. Jack Smith will be very, very prepared for this. And I'm still waiting to see, because there were, where did I put that? There were 4 counts in Jack Smith's DC indictment. Count 1 is conspiracy to defraud the United States. Count 2 is conspiracy to obstruct an official proceeding. Count 3 is obstruction of an attempt to obstruct an official proceeding. Count 4 is conspiracy against rights. Count 1 and count 4 are fine. Jack Smith's going to have to pull out some facts and then see if the remaining facts in the indictment support those 2 charges. But they're both felonies and they carry a lot of prison time. The counts 2 and 3 are based on 18 USC 1512 code section in the Federal Criminal Code that last week the Supreme Court majority said prosecutors overreached in using that obstruction statute in prosecuting J6 insurrectionists who had entered the Capitol. So I don't know if those 2 counts even still apply to Donald Trump. I haven't seen anything definitive on that, because that case that the Supreme Court heard last week was about a defendant who was an insurrectionist, not Donald Trump. So, but this could, it could have the impact of actually streamlining the indictment, narrowing down what Jack Smith actually needs to deal with, and allow him to put on his evidence if Judge Chutkan lets him do that. And I'm confident that she will. So it's, to me, it's a shitty decision. And to me, it is gravely concerning going forward into the future with new presidents. I do think in her dissent, Justice Sotomayor said that this is basically like leaving a loaded gun laying around the White House for the next occupant to come up and fire it. And I think that's accurate. I thought her dissent was a little hyperbolic, but not much. I'm just, I can't remember who it was. I saw one commentator today who, again, thinking in terms of moving forward, described this decision for future presidents as a roadmap of how to become the president of the United States and then turn the Oval Office into a seat of criminal activity the entire time you're there, by couching everything in terms of official acts that are entitled to absolute immunity. And, another one of the things that gravely concerns me is, we think about the Heritage Foundation, who put out Project 2025. I guarantee you they've got a team of 25 or 30 people who are combing through this decision in order to determine what Donald Trump would be or could be allowed to do, because they're going to push that envelope too. And they're going to push that envelope too and go beyond the bounds of the decision and then just try to make an argument later on. And with this Supreme Court, what fear do they have that their decisions won't be upheld as immune from prosecution? Now, on a slightly lighter note, this morning I was just like, well, first of all, let me say this. Today was an absolute shit show on social media on both sides. It's like, I had to drive into the city, pick up the dogs, go to the office. So it was like 9:30 before I even got settled in, West Coast time, so it was afternoon, East Coast time, I open up TikTok and the first thing that I see is a video from some Trump humper, super excited and loudly proclaiming that the Supreme Court had just granted Donald Trump complete and absolute immunity for everything ever for all time. And obviously, that was not the case. And I saw just so many incredibly stupid, gullible people on the right spouting off stuff like that all day long. And there was a fair amount of that on the left as well. And I was feeling very, very frustrated, very, very frustrated today, very triggered, and almost kind of despondent about how these large communities on both sides of this case, the political divide in this country, were reacting, because to a large extent, both sides, both groups, seem to be completely unglued, losing their minds, and disconnected from reality. And it's jarring and shocking to see that in real time on such a large scale. It had an extremely negative impact on me today. And it triggered me, and it made me feel fearful, and and I was angry in some of my TikToks today. And just seeing the sheer just stupidity of things that I saw today, it was just extremely unsettling, and it made me angry and depressed and despondent and sad. And it was just a really, really challenging day. And so it's like, I think it was around lunchtime or something. I was trying to shake that. And I was trying to come up with, what could I put out there that would, like mix things up and kind of turn the debate on its head. So I was looking at the opinion, and I found 3 or 4 examples. Let me see if I can find it. The stuff about the scope, conclusive and preclusive authority, and it was things about the DOJ and immigration and pardons and things along those lines. And I picked like 4 examples, and I couched them in terms of Joe Biden, and I closed it off with Joe Biden is completely immune from any type of criminal prosecution if he decides to make Hunter Biden the Attorney General. It was kind of funny. It was satirical. It was tongue in cheek. It was like a 2 or 3 minute long video. And I put, the words on the screen in all caps. The Supreme Court just granted Joe Biden absolute, complete immunity, with multiple exclamation points. And I posted that. And I think right now that video's got like 500,000 views, and it has 10,000 comments. And it was fun to watch the Trump humpers come into the comments of that video and just lose their minds. Most of the people on the left got the joke and appreciated the satire. I delivered it very deadpan, very seriously. And, but that was more for my own mental health than anything. I mean, after all the Supreme Court decisions we got last week, and, think about this for a minute. In the last, say, 2.5 years, 2 years, in the last 2 years, 2 years ago in last May, starting in May of 2022, this court overturned Roe versus Wade, that had been in place for 50 years. They overturned affirmative action, that had been in place for 40 years. They overturned the Chevron deference standard, that had been in place for 40 years. And then today we get this immunity decision, which sets up authoritarianism moving forward. This court has gotten those 4 things done in less than 2.5 years. And the steady decline and erosion of American democracy from this court, and individual rights and constitutional rights. And, now it's like 2 years from now, are we going to have clean water and clean air? Are those going to exist? It over the last week, and I'm sure it's part of the impact of, 2 weeks ago I had COVID for 6 or 7 days. All of last week and currently, I'm dealing with this post-COVID fatigue and exhaustion. And it's as much mental and emotional as it is anything. And the last several days, since like last Thursday or Friday, it's just like, I'm just like, what are we doing, man? What is happening? What are we doing? What is coming next? What is coming next? And what started that off, I know you guys are sick to death of hearing me talk about this. What kicked off that, 5-day little cycle was Joe Biden's debate performance. And I was just like, we're fucked. We are fucked. We are so fucked. We are completely fucked. Because we'd gotten a couple of shitty court decisions that day. That Thursday night was Biden's debate. Friday morning, we get Chevron. Fortunately, this weekend was good. But then we start off this morning, first thing, with the immunity decision. And I said it in a TikTok over the weekend, I feel despondent for the future of this country. I feel absolutely despondent for the future of this country. I'm trying so hard to feel hopeful, and every time I start to feel a little bit of hope, that rug just gets yanked right out from under me. What are you going to do? So, apart from that, and I do want to close out with something really good. Yesterday was Sunday, June 30th. That marked the last day of our Pride March promo. It was successful beyond anything my brother and I could have ever possibly imagined. And that's because of you guys. And that is something that has been providing me with a tremendous amount of joy and happiness and satisfaction over the last few weeks. Just seeing the progress and seeing the response from you guys for that fundraiser. And we're going to be able to make a really, really big donation to the Kaleidoscope Youth Center in Columbus, Ohio. It's a nonprofit that provides all kinds of support and services for LGBTQ youth, primarily teenagers in Columbus, Ohio. And Columbus is a very gay-friendly city, don't get me wrong, but these kids are still in the LGBTQIA plus community growing up in an insanely backwards red state. Filled with people who hate them. And that can't be easy. And our friend Trans Gretchen hooked us up with that nonprofit, and we're grateful for that. So we'll have some final numbers for you guys in a day or two on that one as we get everything totaled up and do all the accounting and stuff. But wildly successful campaign, just wildly. And again, that's because of you guys. And that, and seeing you guys, seeing the comments that I've gotten on my videos, seeing the videos of you guys wearing your shirts and your hoodies, that has just been such an incredible source of comfort and happiness and joy for me through these last incredibly shitty couple of weeks. And I want to thank you guys for that component of it too. It's like you guys have been doing a tremendous amount to help with my mental health as well. Even though it doesn't sound like it or look like it right at this very moment. Today sucked. Today was such an awful day, man. I'm so glad that today is over. But thanks again, everybody. Thank you to everybody who subscribes and who's bought anything from the merch store and helped out with the Pride promo campaign. Just incredibly grateful for you guys. I really am. So Monday is over. Tomorrow is a new day, and we're not getting any more Supreme Court decisions this year. it's over. I'll talk to you guys soon.